Hello, welcome to Lawfiscal. Welcome to the lecture on Transfer of Property Act 1882. Apart from Transfer of Property Act, we have many laws in place to transfer a property. So that is what we call as law of property. The first law of property is Sale of Goods Act 1930. In Sale of Goods Act 1930, to living person movable property is getting transferred. When a person wants to buy or sell a movable property, for example, something which we can take it from one place to another place, that is maybe a definition of a movable property. For example, a car, a bike, a bicycle, anything of that sort, which we can move from one place to another. So the act is used is Sale of Goods Act 1930. Now, law of succession. There is another law that is called law of succession that is used. A dead person transfers property, either movable property or immovable property, to a living person or living persons. So, a dead person can transfer property in two ways. Then how can the first is will, and we call it as testate, and no will, we call it as intestate. When a person dies with testate, that means he has a will. A will is a correct plan how his property is transferred to those he likes, and law takes control of it. And no will is the person has no clear idea or desire to whom he wants to give his property. So the law applicable is intestate. So a person dies with testate, the law applicable is testamentary succession law. And a person dies intestate, the law applicable is intestate succession law. And Transfer of Property Act 1882 is mainly deals when we want to transfer a immovable property between two living person. Instead of two living person, we can call it simply transfer inter vivos. It simply means transfer between two living person. Transfer of Property Act is an important branch of law of property. It's why because usually if you want to buy or sell a movable property, for example, if you want to buy a furniture, we don't really need to write any document, any sale deed or anything. We can just take it from one place and give it to that person. Or if you want to buy, you just buy it. You get the property physically. But in the case of an immovable property, you cannot take that property. For example, you cannot take a house or you cannot take a portion of a land. So the important factor is the sale deed or the document which has a title deed. Whoever has a title deed is the owner of the property. So how this title deed should be and everything is dealt in Transfer of Property Act. So that is why it is a very important branch of law of property. It is passed in the year 1882. Since it is passed in the year 1882, we have 1882 just beside Transfer of Property Act 1882. And it contains 137 sections and 8 chapters. 8 chapters contains divided 137 sections is being divided in 8 chapters, and it in force from 1st July 1882. So Transfer of Property Act 1882 has 137 sections and 8 chapters. In that 137 sections and 8 chapters, we can further divide as general principles and specific transfer. Part 1 we call it as general principle, and part 2 we call it as specific transfers. And specific transfer is inter vivos only. Inter vivos is transfer between two living person. Section 1 to section 53A deals with general principle, and section 54 to section 137 deals with sale, mortgage, lease, exchange, gift, etc. And Section 1 to 4 is actually preliminary transfer. It comes under Part 1 General Principle. Transfer of Property Act 1882, as we already know, it is a transfer by two living person. We call transfer inter vivos. Two living person, a transfer is been done of the immovable property. But this act, that is the Transfer of Property Act 1882, does not apply transfers by operation of law. Which are the laws being controlled by the operation of law? The first one is Succession Act. The second one is Insolvency. The third one is Court Sales. This is just to give you a graphic representation so that it will keep in your mind. Solid. Okay. And now, if you look at a transfer of property as a big sphere, Section 54 to Section 117, Transfer of Property Act deals only with immovable property. In that small section also deals with movable property. That is Section 5 to Section 37 and Section 118 to Section 137 deals with movable property as well. But if you compare these two, it is considerably less amount of section actually also deals with movable property. But the entire sphere deals with immovable property. So that is the reason we call Transfer of Property Act mainly deals with immovable property only. And there are some involuntary transfers which is not in the control of any living person. For example, Insolvency Act, CPC, etc. that we have already discussed. Now, what is transfer of property? It is significant to note that the Act does not define it. It merely defines the word transfer under Section 5. So here, transfer of property defined in the following sections. This is from the Bare Act. Transfer of property means an act by which a living person conveys property. So that is when a living person wants to transfer, means he wants to buy or sell. In present or in future, he can do it right at this moment or he can write it for the future time. To one or more other living person, he can transfer it to one person or any other person or to himself. So how can a person transfer property to himself? He can write a document stating that for a duration of 10 or 20 or whatever years, this property goes to one person and after that the property comes back to me. So that is how a person can write a property to himself and one or more other living person. So that is the definition of a transfer of property. It is written in Section 5 of Transfer of Property Act. And living person includes a company or association or body of individual, whether incorporated or not. So usually when we have a tendency, living person should be a person who is human being or living. That is not the case. Law considers either a company or any association or body of individuals, that is we call it as trust, is a living person. So Transfer of Property Act, all the laws, all the act in the Transfer of Property Act applicable to company, trust and associations. But nothing herein contained shall affect any law for the time being in force relating to transfer of property by companies, association or body of individual. But if there is any specific law which governs the transfer for the companies, associations and trust, a body of individual, a Transfer of Property Act won't be a problem for that. That is what it means. So we have seen Transfer of Property Act mainly deals with immovable property, but there are some sections deals with movable property as well. We also should know about it. So in Chapter 2, Section 5 to Section 37 deals with immovable and movable property. In Chapter 3 to Chapter 5, Section 54 to Section 117, it only deals with immovable property. And in Chapter 6 to Chapter 8, Section 118 to section 137. It deals with both again immovable and movable property. Do we really need any act or law in order to transfer our property to somebody else? Well, this only happens when there is an issue. So there are many issues happen related to Transfer of Property Act. And before the act, Indian courts settled dispute used to follow English law. English law means a common law which English, that is British, used to follow for all the Commonwealth nations. So they applied the principle of equity, justice, and good conscience. That is, whatever a judge thinks is right, and the judge does what he wants to do. And the problem of that is every person has its own way of deciding what is right and what is wrong. So there is no correct method or rule that a judge should be applied. That caused a lot of issues. Hence, there was no unity in the application of law, resulting uncertainty. So, hence, English people have decided a need of Transfer of Property Act. Hence, an act, the thinking of an act should be there was there. So, in order to create a Transfer of Property Act, a commission was drafted a Transfer of Property Act in 1870. That is actually 12 years before the actual act came into force on 1st July 1882. This set of arrows is a journey of 12 years journey of after being prepared as a draft in 1870. So let's look into it quickly. The transfer of property draft was submitted to a Duke of RG, then Secretary of State, for approval. And from there, after necessary modifications, the bill presented to the Council in 1877. That is how a bill is going. And the Council selected a set of people. We call it as a select committee to examine the bill. And once that they understood it, the law is not good, so they referred it to the second law commission. The first law commission is not able to get it right, so they referred it to second law commission. The bill revised and published in 1878. That is 8 years after the bill again revised. It is not yet become a law. And finally, the second law commission revised the bill in 1878. It is approved by the legislature and received the assent of the Governor General on 17th November 1882 and came into force 1st July 1882. Even though it took around 12 years for the drafting and preparation, Transfer of Property Act is not exhaustive. It does not include all the laws relating to transfer. The first example is this act does not regulate the transfer by proper operation of law. If any transfer of property required by the operation, that is not by living person. For example, court order, insolvency. Insolvency is somebody is bankrupt and how their property should be transferred. Court sale, how the court sale somebody's property if required. An auction, operation limited to act of parties. Transfer of property is an operation limited to act of parties only, and we call it as transfer of property inter vivos. Two living person transfers property. Look at the case of Kishori versus Krishna Kamini. It says a will through succession is not covered by this enactment. So that is, we have a separate law called succession law. And the third is major portion of the enactment is applicable to immovable property only. So transfer of property, as we know, largely deals with immovable property. And a very important thing is Chapter 2 of Transfer of Property Act not affect the transfer of Mohammedans, and Section 129 of the Act expressly says that nothing contained in Chapter 7 of the enactment shall be deemed to affect any rule of Mohammedan's law. So here, Chapter 2 and Chapter 7, does not affect Muhammadan's law. So that is, any Muslim who wants to transfer a property, Chapter 2 and Chapter 7 of Transfer of Property Act does not, will be an interference for them. And it also has territorial limitations. Transfer of Property Act is not applicable to all the states of India. That is why we also has a territorial limitations in Transfer of Property Act. We have Transfer of Property Act, we have Sale of Good Act, we have Succession Act, but still there are some issues that there are no act. So in that case, the court has a case, Tajo Bibi versus Bhagwan Prasad. It says, when a provision of the act is not applicable to a case, the court are entitled to apply rules of English law, not inconsistent with the act of the basis of rules of justice, equity, and good conscience. And it means if a judge thinks a decision is justice or equity and good conscience, and the provision is not there in the act, the judge can decide by himself. That has been decided, or that has been held in Tajo Bibi versus Bhagwan Prasad case. So in order to add many missing provisions, Transfer of Property Act 1882 was amended partially in 1929. Amended means the act actually added more sections, that is more than 50 sections, and introduced some new sections. And that act came into force on 1st April 1930. This is a brief introduction on Transfer of Property Act. If you have any questions on this, you can write in the comment. Make sure you subscribe to this channel, and the next video will be coming today itself, so you don't miss out. So take care and God bless you. Thank you.